Everyone. My name is Professor Christina Nolan, and I teach a variety of legal studies courses with Purdue Global. So I would like to welcome you to this little informational video about filing an SSDI claim. So we will be focusing on that process specifically. But I'll also be giving you a little bit of background information. And so this video is meant to sort of be housed within the Social Security Disability Law course. It is most helpful for the Unit 1 discussion board. But honestly, this information, is useful for just common knowledge and just the understanding of how to file this claim. And so we are going to sort of walk through what it looks like to actually file an adult Social Security disability insurance claim. So that's what SSDI stands for. We are focusing on, again, the adult claim. So let's take a look at what is the difference between SSDI and SSI. You've probably heard these terms. Sometimes they seem to be used interchangeably. So the requirements are different for these two programs. But the definition of disability and the means for proving a disability exists. These are the same for both programs. So they're different programs. But sort of like the what it means to be disabled under these programs and how you prove that, it's the same. So SSDI, which is what we're focusing on today, is an insurance program. And I'll explain what that means, which is different from SSI, which is considered, I hate the word, but it's officially considered a welfare program. So something to benefit the public. We're looking at somebody who's of a vulnerable population in need. There's special definitions for who would qualify under SSI. SSDI is based on what a claimant has paid into the system over their working years in the form of payroll taxes. So, if somebody is on, well, nobody should make you feel guilty about being on either program, but there is often criticism. Oh, you're just using the program, SSDI, if somebody is on that, they've paid into the system like it's insurance. And so if they do need to access those benefits, they're really just taking what they've already paid in. SSI is part of the safety net of programs that in the United States we've decided is necessary to, again, help vulnerable populations. And again, it's the safety net system. And SSI is based on a lack of income and assets. It may still be possible to apply for both in some cases, however, meaning SSDI and SSI. In order to be eligible for SSDI benefits, again, that's the insurance-based system, you have to have worked a sufficient number of years. This is, about 5 years of work during the last 10 years prior to the disability. I've actually done this. If you go onto the Social Security Administration website, you can make an account. They verify your identity and everything officially. Once you make that account, you can actually check to see, if you're just curious, how many number of years have I worked that would be eligible? You can go in there and they will give you a breakdown. So it's always nice to sort of take a look, become familiar. Hopefully you will never need, to access these benefits, but if you do, you'll know what to do. So how do you qualify for SSDI benefits? Again, we're kind of giving some background information to really what the topic of the video is how to file that claim. But you do need this background information just to sort of help you understand how do you file. So to achieve insured status, and now we're focusing on SSDI for the rest of the video. You must have this specified number of credits. Credits, they're also known as quarters of coverage. These are earned by working at a job covered by Social Security. So if you're working an under the table job, like a cash only, or maybe you're babysitting like a nanny, but they're not paying you benefits, it's just sort of a cash only job, that time you've worked for those kinds of jobs would not be qualified. So you're not, essentially, if you're not paying into Social Security, the system, that time that you've worked is not going to go towards your earned quarters or your credits, sorry. So, and that's why, a lot of times people say, those jobs are good for certain, reasons, those under the table jobs, but, ultimately they're a little detrimental because you're working, but yet that time, in case should you be disabled later on, that time that you worked, and sometimes it's a significant period of time, does not go towards those credits. And then, if you're disabled, you wouldn't have the benefit of this system. So every year, the commissioner of the SSA determines the amount of earnings from work that is required to earn a credit. This is a thing that is done yearly. In 2006, an earnings amount of $970 earns one credit. And a worker can earn up to 4 credits a year. And now insured status for disability benefits is subject to a 2-part test. The worker has to be fully insured, and they must also have current work. So again, it is a more complicated analysis. This is why, in many cases, people do file for this on their own. The government website makes it fairly easy. The information is all available. So it is possible for someone to file for this on their own. But it is also helpful to have someone helping you, a representative, which we'll talk about later. To be fully insured, a worker must have between 6 and 40 credits. And this depends on their age, the worker's age, at the time their disability began. For current work, so this is like they're currently working, the worker needs to have earned at least 20 credits during the period of 40 calendar quarters that ends with the quarter in which the disability began. So again, it's a little bit of you need a calendar, you need a calculator. Special rules, though, apply to persons younger than 31 or people disabled because of blindness. So another consideration, and again, this is all background information, is there a waiting period for benefits? Do you get them right away if you're approved? Well, a wage earner seeking SSDI, they have to meet a 5-month waiting period requirement before receiving cash benefits. The 5-month waiting period is intended to provide time for most temporary disabilities to improve. So disability is really based on the fact that, hey, you are disabled, you cannot work. We're not expecting improvement. So if, it's possible for you to have some sort of temporary disability, you can't work for a little while. Maybe you apply for SSDI thinking, well, what if this isn't temporary? But let's say within that 5-month period, you improve. I mean, that's kind of what you'd rather have anyway, right? You'd rather improve to the point that you can go back to work. You don't need these benefits. So they're just kind of giving it a little bit of time. It can be cumbersome for people because let's say somebody is clearly disabled, to have to, wait those extra 5 months is a pain. So the waiting period has to last 5 full consecutive calendar months. If the disability is alleged to have begun in the middle of a month, the 5-month waiting period will start the next full calendar month. And there is no, they have to enforce this rigidly. There's no, can you talk to someone and they'll, waive it for you? No. This is they're pretty strict. And so, you've already had a little snapshot of the background information and what you need to do to qualify. Then we talk about non-lawyer representatives. So this makes sense. An individual has a right to have a representative assist them when they do business with Social Security. It can be an attorney. It can be a non-attorney. This is helpful. The representative cannot charge or collect a fee in most situations without first getting written approval from the SSA. We don't want people to be taken advantage of. This is called fee authorization. The representative can accept money in advance, but only if that money is held in a trust or escrow account until SSA authorizes a fee. So you cannot take the money until you've got that fee authorization. Both the claimant and the representative are responsible for providing SSA with accurate information. Knowingly providing false or inaccurate or false information could result in criminal charges. The key is knowingly. If it's an accident, it's an accident. This is a profession that a lot of people who don't want to become lawyers, but they'd like to represent people. This is one of those exceptions to the unauthorized practice of law because it's specifically authorized by the agency. You can be a non-lawyer representative. So you are appearing in front of, for most steps of the process, in front of an administrative body. It's kind of a nice, career path. Non-lawyer representatives can help claimant obtain medical records or other information necessary to support their claim. They can attend an interview, conference, or hearing. The representative cannot testify in the claimant's place at a hearing, which makes sense. We're going to let the claimant speak. The representative can also request a reconsideration, a hearing, or an appeals counsel review when the claimant disagrees with a decision and wants to appeal. They can help the claimant and witnesses prepare for a hearing and questioning any witnesses. So you can see they're kind of doing some of the jobs that lawyers do. So it's kind of cool. You will, so what has to be done by the legal professional before the claim is submitted? And again, we're still talking about the filing of the claim, but again, this is helpful knowledge to have before we get to this filing of the claim. The legal professional, the non-lawyer representative, whoever is helping the client, you have to find out the basis for their claim. You've got to talk to them. Then it's your job to verify, are these claims supported by the medical records? You don't want the client to waste their time filing if there's, what they're saying is not supported by the medical records. Now, and you have to get the complete set of the medical records. You need to review them in their entirety. But let's say you think that, well, maybe there is a case here. Maybe there is something to this here. But maybe your client or the potential claimant hasn't seen a certain doctor, a specialist. You might not want to immediately say, no, your claims aren't supported by well, you can say that, but you can also say, but I think you might have a case. Let's go get some additional treatment. Okay. And so again, that's another discussion for another video. But let's just say all hope isn't necessarily lost if the claim isn't supported by the records. If you feel like, no, they still need to see some sort of a doctor to verify what they clearly have, right? You don't want to send somebody away who could potentially qualify just because they don't have the records. That's your job, is helping them get those records. Here's some examples of, types of medical records. And then we have a doctor opinion letter. This is, again, the claimant could do this themselves. If you're helping them, you could do it. You may want to request the doctor that, their opinion letter, kind of like give your opinion on what's going on with the claimant. And this can really help your claimant's case. It can hurt it too. Okay, so filing the claim. And again, we're focusing on adult claims for SSDI. And we are, so I want you to understand what this process looks like in real life. Um, as you kind of have seen already, SSDI is structured, evidence driven, and there are specific rules that you have to follow. The way that you file that initial claim, it matters. It's really important. A strong filing builds a foundation for everything that follows. So again, we know, we've all heard, oh, they reject you the first, at the first attempt, and you've always got to appeal. Um, you know, um, what's the word? I can't think of the word, but we definitely hear people saying that. Oh man, I have it on the tip of my tongue. Can't think of it. But if you have that strong initial filing, you've got all your ducks in the row, you're giving it your best shot, and you've set up that foundation for, well, maybe you have to appeal, but you've got that strong foundation. Maybe there was just a little something wrong or a little something extra you need to get. But you've got that good foundation. All right, so let us now look at some of the threshold questions that are asked. So before you start the paperwork, and again, we've talked about some of these things already, you have to check two things. First, does the individual meet the federal definition of disability? What does that mean? This means that they have a medically determinable impairment that prevents substantial gainful activity and is expected to last at least 12 months or result in death. So remember, we talked about that 5-month waiting period. This is something that, and again, I think I said permanent, but it just needs to be expected to last 12 months or more. So forget what I said about it being permanent earlier. Just 12 months or more, or death. Death is permanent. Second, are they insured under the system? That's another inquiry that you have to make. Again, SSDI is based on work credits. If the person does not have enough recent work credits, the claim cannot move forward. You're done. That being said, if they don't, that's when you may be able to investigate, could they potentially qualify for SSI? But that is, again, beyond the scope of this particular video. So answering yes to those two threshold questions will determine whether or not you even want to file. So now we're going to move on to, I know you've been waiting for this, the application. So what is this? So once you've met those, you've answered yes to those two threshold questions, now we begin the application process. And you want to do this in a timely manner. Your client is, they're waiting. They obviously need this money. So you want to do everything as quickly as possible, at least from your end. You can't control the government and how quickly they will move, but you can control how, again, if you are a non-lawyer representative, if you're working for a lawyer who is representing, you want to make sure that at least your part is done quickly. The filing includes the formal application and the adult disability report. In these documents, you're listing treatment providers, medications that your client is taking, education, and work history going back 15 years. So you really want as much information as possible. And if that takes a little bit of time, take that time, because if you don't include something, that could potentially make or break the case. So the most important part of the report is how the condition limits work activity. Why are they unable to work, or are they limited? So this is what Social Security evaluates. Now we're going to look at functional limitations. So a diagnosis alone doesn't win a case. Possibly blindness, but not necessarily. So Social Security looks at function. Can the person sit for extended periods? Can they stand? Can they lift? Can they concentrate? Can they interact appropriately in a workplace? What about sustaining full-time work activity? So a little hypothetical, my neighbor, it's a little different from him because he was injured at work. And he was actually deemed permanently disabled. But what was interesting about him, super, super smart guy, doing very, very heavy labor, concrete work. And his education only went up to the 8th grade. So he can sit, for some extended periods of time. Can he sit and work at a computer? No. I mean, the lack of higher education is limiting. So again, that's kind of what you're looking at. Is you don't just automatically say, he's paralyzed from the waist down. Well, he could do computer work. He could sit all day at the computer. Well, we have to look at his age, his education, all these other factors. So the claim has to translate medical problems into work-related limitations. And again, this is where many of these initial applications fall short. They're not making that connection. So the next slide deals with medical evidence. So what do you need to prove your case? Medical documentation, not just your client telling you this happened. Documentation. This is the backbone of the claim. Certain types of medical evidence, those listed on the slide, these are all very helpful. Mental health records are listed. Obviously, those are only necessary if they are related to the claim of disability. A claimant is entitled to privacy. So if the mental health records have nothing to do with why you're asking for disability, you are not going to be submitting those. Same for medical records that don't apply to why the claimant is saying they can't work anymore. The evidence that you have should show limitations over time. Incomplete records are one of the most common reasons for the initial denial. And then consistency also matters. The statements in the application have to align with what appears in the medical records. It all has to match up. It all has to coordinate. You want to make it as easy as possible for the SSA to kind of see that. You don't want to have to explain it. You want it to be obvious. So what happens after filing? After the claim is submitted, Social Security reviews non-medical eligibility first. So they do that initial determination. Do they have the work credits? What is the status? Are they insured? Then the file is sent to Disability Determination Services, DDS. They review the medical evidence and they review it pursuant to the federal regulations. They may request additional records. They may schedule a consultative examination if the file needs development. So they're fair too. I mean, this is they're an agency trying to help, people in the United States. They're not your enemy. But they have to follow federal regulations. So the consultative examination, if they see that is necessary, they'll schedule that. And so again, this decision, they're not the enemy. They're just trying to base their decision on the process. And so this is a little bit beyond the scope of the video, but I just wanted to include it here. Maybe down the line, we'll do another video on this. But this is what you look at down the line. So once that claim's filed, what happens to it? This 5-step sequential evaluation process is what the agency uses to analyze and evaluate the claim. So step 1 asks whether the claimant is working at the substantial gainful activity level. So obviously, this is important. Step 2 considers whether the impairment is severe. Step 3 asks whether the impairment meets or equals a listed impairment. So, and again, that's a whole other inquiry, but is what the claimant has. Does it meet something that's already listed? And then step 4, can the claimant perform past relevant work? Step 5 considers whether the claimant can adjust to other work in the national economy. Okay, they can't do their current job. Can they do something else? And that's where I sort of brought in my neighbor who could not. And every determination follows a structure. Nobody skips this. So here's a little hypothetical. You've got a 52-year-old warehouse worker. I don't know. It's a bear. So he is, had back surgery, chronic pain. Imagine his application just says back injury. Can't work. There's not a lot for the agency to go on. I mean, we all have back problems, right? I guess if he says back surgery, that's a little better, but they need to verify. Where's the verification? But if the record includes surgical reports, imaging, clear evidence that this bear cannot stand, or he can only stand for 15 minutes, cannot lift more than 10 pounds, this would connect directly to the past heavy work, and then those 5 steps in the evaluation process. So again, show me how we got to this statement that can't work. Had a back injury, can't work. How do we get there? Let me see why. Let the agency look at all that evidence. And so, sorry about that. The onset date. So this is an important inquiry too. The alleged onset date matters. Why? Because it affects the 5-month waiting period before benefits begin and can affect retroactive benefits. So the onset date, of course, has to align with the medical evidence in the record. So you're really just matching things up. And I just had this thought in my mind. This is where, as we always like to talk about artificial intelligence, this is where an AI tool, I'm not sure which one, but I could see an AI tool being really helpful here. You would just plug in your medical evidence. I don't know if I'd upload it all, but just maybe generically plug it all in, plug in what the agency evaluates and how they evaluate. See what the artificial intelligence tool says. And what I would mostly be looking for is, where are there gaps? What do I need to get? Because, when you're so close to things, it's hard to really see. But that tool could sort of show you, oh, wow, we don't have anything to prove this. So then you could go out and get that evidence or have your client see a doctor, another doctor or specialist. And so, slide. What is the role of the attorney or paralegal in the process? We've talked about this sort of ongoing through the video, but really it can be broken down into confirming the insured status, gathering complete medical records, ensuring consistency across documents, aligning the evidence with the legal definition of disability. And again, you have to be precise. And you are also, I would recommend, you're also explaining to the claimant along the way what is going on here. Don't let them know, hey, you might get initially denied. We're going to file an appeal. So you don't want them to get desperate, to get worried, to think that you are not doing anything, right? Because a lot of times this takes time. What are you doing? So this is where communication also matters. Email, text, phone calls, keeping them updated, even if nothing's happening. Just say nothing's happening. This is what we expect to happen. I don't know how long it's going to take. That's enough for them, though. And so just a couple of wrap-ups. Filing an adult SSDI claim is structured, evidence-driven. And I also want to mention there is a lot of information about this on the SSA site. It is the most accurate information as well, up to date. You always want to look at that. A lot of times law firms write little articles about it. Those are often helpful because they'll kind of give you little strategies, especially if you're not going through a lawyer. But obviously always look at the date of those articles, because you don't want to be looking at something from 5 years ago, because that might not be accurate. Um, the functional limitation of the claimant is central to the case. Is the disability preventing them from working? Any substantial gainful activity? And then remember that strong initial filing is that foundation for the claim. And if you need an appeal, reconsideration, hearing, anything that follows, you've got that strong basis. So you always want to really put your strongest case forward at that initial filing. All right, everybody. This was not as short as I thought it would be, but I hope you enjoyed this, and I hope that you found this to be informative. And I thank you very much.